Good? Mm-hmm. All right, y'all. This is a special request video from Brandy. Good thing is, for this YouTube video, I was already in class. You can scan now and show the class. So, it was actually perfect timing to show everything that we've already talked about anyway. So, Brandy asked, what is the protection of your house if an intruder breaks in? So, we're going to break it down. And the first thing to understand is what the self-defense law in the state of Georgia is. Now, for you guys out there watching my YouTube video in other states, research your own state laws, okay? This applies in Georgia and Georgia only, all right? Now, nothing, I'm not your lawyer, so this is not legal advice for you. I'm only giving you how I teach law in my classroom, all right? So don't just take what I tell you and go with it. Make sure you go study it and apply it for yourself. Alright, so let's start with 16.321. 16.321, and y'all make sure y'all take notes, but 16.321 is the self-defense law in the state of Georgia. The law reads that, and I'll read it straight off this case law, it's basically, where we at? It says if a person is justified in using force or threatening force against another when to the extent that he or she reasonably believes that force is necessary to defend himself or herself against such others' imminent use of unlawful force. Now, it also goes to state that that force must be a forcible felony used against you or being used against a third party. So when that force is being used against you or a third party and is a forcible felony, then you can utilize force. There are 3 times in the state of Georgia where you cannot utilize self-defense as a affirmative defense. Number 1 is when you invoke the fight. Okay, if you invoke the fight, that is not a proper defense. Okay, what does that mean? Let's say I'm an officer and somebody says, if you take these goddamn handcuffs off on me, I'm going to whoop your butt. And what do? I take the handcuffs off and they whoop my butt. I cannot use the self-defense law to protect myself. Number 2, if it is a regular felony, if the person is fleeing from the commission of, on the way to the commission of, or during the commission of a regular felony, I cannot utilize the self-defense law to stop them. Basically, I cannot shoot them during the commission of a regular felony. An example of a regular felony would be white-collar crimes such as fraud, bad checks, or things like that. Even breaking into your car and nobody's in the car is considered a regular felony. You could not apply deadly force to them. And then number 3, if you are involved in mutual combat and no one makes the indication that you must stop or I want you to stop, then I cannot use force. Okay, the fight must be severed. Everybody on both sides must know that the fight has stopped, and then you can use force against that person. All right, or self-defense, not just force, self-defense. Now, let's talk about State versus Green. State versus Green opened up a very, very good understanding of what the self-defense law actually says. Self-defense law was misunderstood by the Fulton County DA's office, all right, where it came to this case right here, State versus Green. Basically, Green had a knife that he used, or that he was utilizing at the time, to protect himself from a guy named Walden, all right? Now, he wasn't an aggressor to Walden. Green just had the knife for his protection. He told Walden, don't hurt me, don't come towards me, or I'm going to utilize my knife for self-defense. Walden ignored him and therefore struck Green in his head with his head. Okay? Now, to understand what the other requirements are in self-defense, it says that a person must either be causing or getting ready to cause serious bodily injury, which is defined as protracted loss, disfigurement, loss of use, or loss of consciousness. Alright, so I mean, if I cut their finger off, if I headbutt them in the head and they go get a concussion and go unconscious, or something to that effect, or something that's considered serious in nature, then that is enough for me to utilize the self-defense law. And also, of course, we already know death. If the thing that they're going to do is going to cause death, I can defend myself. Okay, so if somebody's getting ready to swing a bat at you, you can defend yourself. If somebody presents a gun to you, you can defend yourself. If somebody has a knife and they're getting ready to present it to you, I can defend myself. And what State versus Green said is that Green could prepare himself for that fight. What they tried to do in this case was charge Green as if he was an aggressor. he did nothing more than stand there with his protection. So they tried to say that it was a fight and he had an unfair advantage with the knife. He was doing nothing more than protecting himself. All right? So, go on to here, 16.323. 16.323 is the self-defense law for habitation. Habitation is defined as your home, your vehicle if you're like at a camping site, your RV if you're at a camping site, your tent, a hotel room, okay? Whatever your habitation is for that night, and make sure you read it on your own in the legal definitions, but you can defend habitation if the person poses a unlawful act or threat of harm to people within, and they break in your house in a violent or tumultuous manner. Okay, now, same way you had 3 categories in 16.321, you also have 3 categories in 16.323. The first one being if the person breaks in a violent or tumultuous manner. What does that mean? Anybody?
Kicking in your door.
Kicking in your door, breaking your window. They're basically using force to break in. Okay? Number 2, this is going to throw some people off. Number 2, you cannot use 16.323 to shoot somebody coming into your house if that person is a member of the household, a member of your family, or a member that has basically set up that dwelling as their own. Okay? What that means is when you get in an argument with your boyfriend and your girlfriend and you kick them out and they try to break into their own house, you can't shoot them. Okay? You cannot shoot somebody for trying to break into their own house. It's not illegal to break into your own house. Alright? And the law actually covers that in Part 2. Part 3 is the most interesting one. This law tells you that you can shoot somebody for a regular felony. Okay? Up here we know that it has to be a forcible felony, which means what? The threat of harm or the harm to another human being. But down here, the regular felony that you can shoot somebody for is burglary. And it says that if that person is breaking in for the attempt to commit a felony therein, then I can utilize this law to stop them. Okay? The law says that I can stop or terminate such others' unlawful entry into. So people always ask, well, can I just shoot them at the door? Again, read the law, understand it. The law says verbatim to terminate. All right, guys, look, my battery went dead on my phone. So, back at it. In 2006, they had the Castle Doctrine law that was presented. All right? 2006 created what we call today the No Retreat Law. Okay? No Retreat Law is 16.323.1. Alright, what the No Retreat Law says is that I can stand my ground. Okay? Basically, shoot now, ask questions later, if that's the way you want to look at it. But basically it says that I do not have to run from a fight. Okay, I can stand my ground and fight right now, and then I can call the police and come and get them later. Alright, you understand that? Basically, back in before 2006, you had to go to the furthest edge of your house before you could fight. Okay, not today. Today, yeah, in 2006, and there's still some states, I believe, that still have that same law in place.
When somebody breaks in your house?
Breaking your house, you had to run to the furthest corner, furthest whatever, before you could apply force.
It's hard.
Not no more. Okay? That even applies to your regular self-defense, 16.321. If a person is trying to fight you or rob you, you same thing. You'd have to run to the nearest point to try to get away from them before you could respond back to them. Okay? And then, of course, you have the one that everybody's probably thinking about, 16.324.2. And this also got brought up in State versus Green. Alright, and 16.324.2 is your immunity from prosecution. That means that you cannot be prosecuted for murder for shooting somebody during a self-defense situation. Alright, where it comes to self-defense is self-defense. They cannot come and say manslaughter, involuntary manslaughter, or anything else. They have to take it for what it's worth. Now, in order to get immunity from prosecution, law also says that you must provide proof that you are in defense of self. Okay? Another thing you're going to have to provide proof of is that you were in legal possession of the weapon that you used to defend yourself. Yes, ma'am?
Can you shoot a person if they come into your house and you do know the person though, but they not supposed to be in your house?
If they do not live in the house and they are breaking into your house, they're just another subject. Okay? Only people that live in the household or are a member of your household. Now, obviously, what the law wanted to do is separate domestic issues versus realistic issues. Realistic issue is that I just dumped this guy and now he come back over here to kill me. You're not gonna be charged for that because he was realistically trying to come over there and hurt you. Okay? He was trying to offer violence therein, which is another part of the law. Okay? They're not gonna cut you off for that. But you will be caught, because I was typically like, think mentally, right here, that morally I have to be right. So if I know my boyfriend's coming to kill me, and, I know my boyfriend's coming over to have a good time with me, it's going to be in my text messages, it's going to be everywhere else, so I'm going to shoot him, and forensics is going to find out the details later, okay? Always be righteously right, morally right, all right? And so, going back to this, immunity from prosecution basically says, again, that you are immune from any prosecution that they would try to bring up against you if everything falls in place. You legally possess that gun. You legally possess that knife. You legally possess everything that you utilize to present self-defense for yourself against that person. Everybody got it?
Yeah.
All right. Hope you got it, Brandy. That's it. That is basically the law. Make sure you go and read it for yourself. Remember, I can't be there for you to help you apply it on somebody, and I can't be there in court for you. I'm not your lawyer, and it's not legal advice. This is just me teaching the classroom how to understand the law. All right? You know I love you. Y'all keep doing shit. All right, forgot one thing. As far as having a gun in the house, right now the state of Georgia does not have a law against you having a gun in your own home. You do not have to have a license to carry in your house. And if you want to carry it outside the house, other than your car, you have every legal right to carry in your car. But outside of your car in a public place, you would have to have a Georgia weapons license. All right, go to your nearest probate court, your county's probate court, get the proper documentation before you ever strap a gun on and go outside the house or away from your car. But inside your car, you can carry a gun anywhere you want to, and inside your house, you can have a gun. Okay, so I hope the video served you well, and